Legislation is a major source of employment law in the United States. There are primary federal laws as well as state statutes and local ordinances that affect the employer-employee relationship. Not surprisingly, these laws frequently conflict, and courts must decide whether one government body's law preempts another. The term preempt generally refers to displacing effect that the federal law has on conflicting or inconsistent state law under the Supremacy Clause of the U.S. Constitution, Article 6, Section 2, but it also refers to the displacing effect state laws have on conflicting local government ordinances. Confusion also occurs when Congress attempts to abrogate sovereign immunity by passing laws supposedly giving state employees the right to sue their state employers. The 11th Amendment of the U.S. Constitution creates a federal system in which each state is a sovereign entity and can be sued only if it consents to be sued. Congress can abrogate this immunity only if it unequivocally expresses its intent to do so and creates a remedy congruent and proportional to the wrong addressed. Judicial opinions are another source of employment law. The United States is a common law system. In contrast, in a civil law system, comprehensive statutes or codes enacted by a legislative body cover almost every subject. A manager seeking to apply the law expressed in a judicial opinion should be aware that only controlling court decisions must be followed. In the federal system, the U.S. Supreme Court sits at the pinnacle. The 12 circuit federal courts, known as appellate courts, make up the middle, and the 90 federal district courts, trial courts, constitute the base. For a court's opinion to be a controlling precedent or binding precedent, it must have been written by a court directly up the pyramid from the lower court. The Supreme Court's interpretation of federal law controls all circuit court decisions, but circuit court opinions binds only the few district courts located directly below it in the pyramid. Federal and state constitutions create legal rights as well. In the U.S. Constitution, the 1st, 4th, 5th, and 14th Amendments conspicuously shape the employment relationship. The Equal Employment Opportunity Commission, known as the EEOC, and the U.S. Department of Labor are responsible for most federal employment laws, and they publish materials about these laws. State agencies enforce and administer state employment laws and publish related materials. While an agency's interpretation of a statute is not binding on a court, courts defer to agencies because of their expertise. Notice the differences among criminal, civil, and administrative laws and procedures. They're important from a human resource management context. Civil law disputes take place in court, usually but not always before juries, and involve private or government parties seeking to determine their rights vis-a-vis each other under civil laws. Administrative law disputes are handled by agencies. Typically, an administrative law judge holds an evidentiary hearing to determine the facts, and an agency head makes a final decision. Procedural rules favor speedy resolution, with short timelines, few motions, and little discovery. The last fundamental principle to bear in mind is the notion of remedy. The remedy is an agency's concrete risk. The remedy is determined by the legal claim being made and the losses suffered. A famous legal maxim holds that where there's no remedy, there's no right.